Ever wondered if you really need a power of attorney, a living will, and a last will and testament? Well, we'll tell you the surprising truth tonight on Toronto Speaks Legal Advice. Welcome to Toronto Speaks Legal Advice. I'm your host, Natalka Falcomer. Tonight we're discussing why you or a loved one needs to talk about your final wishes, and you have to put it in writing. I have the pleasure of welcoming one of Toronto's most distinguished wills and estates lawyers and mediators into the studio tonight. We'll be speaking with Tony Baker, who not only sits as an adjudicator and presiding lawyer on the Consent and Capacity Board, but who also taught the principles of negotiation and mediation at various Ontario post-secondary schools. Welcome, Tony, and thank you for coming on. We are going to have a lot of calls today because there are a lot of things to cover and it's quite confusing. Of course, to our viewers at home, if you are at a position that you think you need to talk about a will, or you know somebody that does, you have questions about mental capacity or whether or not you need a power of attorney or what even a power of attorney is, please give us a call. We're here to help. So let's just answer those questions. A living will, a will, a power of attorney. There's different kinds of those. There's continuing. Tell us the difference. Start from the very top for us, please.
Okay, so generally when I have clients coming into my office and they ask me about estate planning, the first document we talk about is the will.
Okay.
And the will has been around for a long, long time. Everybody knows that a will is a good thing to have. You appoint an executor, and the executor follows your wishes and distributes your estate as you direct the executor to distribute it. The other two documents, which arguably can be as important as a will, are the power of attorney for personal care and the power of attorney for property.
Yeah.
Now, if you don't have a will, the Succession Law Reform Act stipulates how things are distributed. So basically in Ontario, if you don't have a will, the first $200,000 goes to your spouse, and then the rest gets divided between your spouse and your children. If you have a power of attorney for property, you can appoint somebody to do things on your behalf while you're still alive. So for instance, if you are incapacitated, you're in the hospital, or if you're in a coma, you're alive, so you don't look to the will to see what happens after you're gone because you're still breathing. What you have to do is look at the power of attorney for property, and if you've appointed somebody to act on your behalf, they can pay your mortgage payments, they can fix your roof, they can do anything you can do with your money except make a new will. So a power of attorney for property, it's now called a continuing power of attorney for property, is a very important document, and I recommend that everybody have one of those because it's a safe stopgap measure for an unforeseen circumstance. Now, the power of attorney for personal care is a relatively new document that came into existence in Ontario in the 1990s, and it deals with healthcare decisions. So, if you want to appoint somebody to make healthcare decisions on your behalf, if you are again incapacitated, and the example I like to use is I have some clients who are Jehovah's Witnesses who don't believe in blood transfusions. And I've got one lady who's got a couple of daughters, and one of them is a Jehovah's Witness and one of them isn't. And she's appointed the one who is a Jehovah's Witness to be her attorney under the power of attorney for personal care, so that, God forbid, she's in a car accident, she's bleeding to death in the hospital. The doctor, if there wasn't a power of attorney for personal care, is in a classic dilemma because one daughter who isn't a Jehovah's Witness would tell him, you've got to give her blood transfusions. And the other daughter would say, no, we don't believe in that. You have to let God take her if we don't believe in blood transfusions, which we don't. So in this case, my client has appointed one daughter who is a Jehovah's Witness to make that decision on her behalf. Now, the living will, so-called living will, is an oxymoron, and in fact, there's no such thing really as a living will, because a will deals with what happens after you're gone. But the so-called living will is what I call a clause that we put into the power of attorney for personal care.
Okay.
So in my power of attorney for personal care, excuse me, there's a clause, and the living will is it's a healthcare directive, and it tells your healthcare providers, your doctors, etc., if certain circumstances come to pass, what your wishes are. So the classic term is no heroic measures.
Right.
Most people, most of my clients, they want to have a clause in there that says no heroic measures if the only thing that's keeping me alive is a machine, and my heart's still beating because a machine's keeping it beating, but in all other matters I'm basically gone. You can pull the plug, so to speak. It's a little grim, but that's basically what the no heroic measures living will clause in a power of attorney for personal care says.
Oh, that's a mouthful. And of course, if anyone at home has some questions, if they're looking at putting a will together, a power of attorney, they want to understand who they can appoint to take care of their estate, and also perhaps you're in a situation that you've been appointed as the attorney for someone in a situation, give us a call. I'll be happy to help you. So back to this whole living will, power of attorney. Now, when does a power of attorney kick in? So there's a common fear where people enter into a power of attorney and they feel, oh, I might as well have just given up all of my rights. Is that the case? What happens?
Well, as in most areas of law, we always start with a document. So we can tailor-make powers of attorney to fit different situations. Most people want what we call the continuing power of attorney for property. And the continuing part means it continues in the event of your incapacity. So you do a power of attorney for property when you're 40 years old, and then you put it in a drawer and you don't look at it again, and then you're 95 years old, life has gone by quickly, and you've got Alzheimer's disease. So you're incapacitated, you're incapable mentally. The continuing power of attorney is still a valid document. In the old days, they just called them powers of attorney, not continuing. And depending on how they were drafted, if you became incapable, the power of attorney became invalid. So most people don't want that. They want to do the power of attorney for property, and they want to appoint usually a wife or a husband or children. And it's valid as long as they're alive. As soon as they die, it's invalid. It dies with you. But what most people don't realize with a continuing power of attorney for property is the outside world can rely upon it. They don't have to look behind it. So if you do a continuing power of attorney for property, and I've had this situation where a mother has a son who
And we've about 90 seconds, just to keep that in mind. Go ahead.
Okay. She appoints her son who she trusts implicitly, and it turns out the son has a few nasty habits.
Oh, dear.
And he goes to the bank, and he cleans out her bank account, and there goes her old age retirement plan, and she doesn't even know about it.
She wasn't in a position of being incapacitated or anything like that?
No, because the bank, they see it, and they can rely upon it. So if somebody has a power of attorney for property, it's probably the most powerful document in all of common law, and banks have to accept it, financial institutions have to accept it, and it can be abused. So that the key is you only appoint somebody that you really trust, because it's open to be abused.
Could you, we have about 45 seconds.
Okay.
One question that we'll get back to, I want to know, how can we limit that authority? Maybe perhaps the ways not to tell the person that you've appointed them, and so on. And we'll think about some of those questions and those problems. And of course, if there's anyone at home that has any questions about what to do if they're drawing up their will, where they can find these documents, if they are appointed as someone in the power of attorney to take care of somebody, their property and so on. If you have any questions about that, please give us a call. We're happy to help with Tony Baker. So one quick question.
Okay.
Oh, actually, you know what?
Okay. Break.
We have only 8 seconds left,
Okay.
so we'll get back to it.
Okay.
And we'll be able to answer some more of those questions later on. Of course, when we come back, you'll not only watch lawyers do something incredible, give away legal advice to no bill, but you'll also get the insider tips you need to help your family avoid a legal battle. Welcome back to Toronto Speaks Legal Advice. I'm your host, Natalka Falcomer. We're joined today by one of Toronto's best wills and estates lawyers, Tony Baker, and we're answering your legal questions about what you need to do to protect yourself if you get sick and to protect your estate. Of course, if you're in the position right now where you have to consider drafting up a will, a power of attorney, if you're appointed to basically direct as an executor of an estate, please give us a call. We're happy to help. We're happy to answer your questions on anything to do with wills of the estates. Back to the earlier question though, so are there any preventative measures that you can put in place if you have a power of attorney for property and so on to make sure that nobody does abuse it?
Yes, you can limit it. By way of example, I have in my law practice people that buy and sell property, they buy a cottage, and they may be out of town when the deal closes, and so things have to be signed. And they'll routinely appoint me as a power of attorney, as an attorney under a continuing power of attorney for property, and we'll say that this power of attorney becomes null and void, you know, the day after closing, for instance. And again, you always look at the document to see if there's any limitations in it, whether it's limited by time or whether it's limited by this person, you know, provided they're under the age of, you know, 30. You can, like I say, tailor make it.
Can you appoint just about anybody for your power of attorney, personal care or property?
Yeah, as long as they're over 18 in Ontario. And remember, all of the subject matter that we'll be talking about tonight related to real estate or attorneys under property or personal care, it's only for the province of Ontario. So each province in Canada has different legislation. Some of them are similar, but anything that I'm talking about is only relevant for Ontario's purposes. But sorry, what was the question again?
No,
limiting it.
Yes, limiting it.
Yeah, I mean, you can, it depends. The general rule is you want to have, it's kind of like a security blanket. So generally most people want to have somebody that they trust, a spouse or a child, and they want to leave it unlimited so that there'll be no restrictions, because if they trust them implicitly, why would they want to restrict it? But if, like I say, you want a professional person to be your attorney for a limited purpose, it's easy enough to draft it just to limit it that way.
Okay, so there's some things that you can put in there. Or also, of course, there's a powers of attorney for personal care that only kick in when someone becomes mentally incapable. Is that the case?
Again, you could limit it. They don't call it a continuing power of attorney for personal care. It's just called a power of attorney for personal care. But the power of attorney for personal care would only be used if you were incapable. So the law in Ontario is a doctor can't touch you without your consent. So if they want to give you a blood transfusion, or you see it in, you know, psychiatric wards, do they want to give people shock therapy? They've got to go to the patient first, and the patient says either yes or no.
Right.
And then if the doctor thinks that that person is incapable, that they don't have the ability to understand the consequences of their decision, if they're declared to be incapable, then the power of attorney for personal care would appoint the person to make that decision on your behalf.
Well, what happens is, for example, I've seen this happen a lot, and I'm sure some of our viewers at home have the situation where a parent already has Alzheimer's or has some sort of mental dementia issue, and they don't have a power of attorney for personal care or property or even a will. Can they create one at that point?
No, not once. Well, any lawyer that drafted a document and had it signed by someone that was incapable shouldn't be practicing law, because that's gross negligence.
Oh dear.
If somebody comes into my office and wants to sign one of these documents, I ask them, I have a whole list of questions to make sure, in my view, that they're capable, that they're understanding the consequences of what it is they're trying to achieve. If someone is found to be incapable regarding the management of their property, immediately when that capacity finding has been found, the public guardian and trustee becomes the substitute decision maker.
Oh, okay.
If there is no power of attorney out there.
Okay.
If there is a power of attorney out there, the attorney named in the power of attorney becomes. So it's a hierarchy. So the power of attorney named in your power of attorney for personal care trumps the public guardian and trustee. But if there is no power of attorney for personal care, the public guardian trustee steps in.
Sorry, go ahead.
And they become what's called the guardian of property.
Yeah.
And generally what they'll do, though, is they're a very, you know, they're a good organization, and they'll work with the family to determine who basically should be carrying the ball. Everything legally will go through the public guardian trustee, but they'll draw up what they call a management plan.
And, you know, before we go there, we have someone patiently waiting on the
Okay.
line for us. But we're going to have to get back to that because
Okay.
I want to talk about next is what happens if nothing is in place.
Okay.
So thank you so much, Mike, for holding. Mike, go ahead. We're here to answer your questions.
Hi, Tony.
Hi, how are you, Mike?
Hi.
Great, and yourself?
Good.
I'm just kind of curious what would happen in the situation where, in a will, a person leaves an asset that's depreciating, and then at the time of their death, you know, let's say it's a $500,000 sports car, and then at the time of their death, it could be worth little to no value. How would you administer the estate in that situation?
Okay. So it has to do with the depreciating asset, Mike, and your question is, when it's a depreciating asset, how do you administer it? Does that have to do with a valuation issue?
I guess, yeah. Maybe Tony could help me out with that one.
Okay, so I don't want to get too complicated, but not every asset has to be so-called probated. We're not even supposed to use that word anymore because it's a Latin term, but everybody still uses it. So